Happy virtual greetings to everyone. Hope everyone is doing well. Hope everyone is enjoying Open Source 101. This is one of those fantastic conferences. One of my favorite ones. Todd Lewis and the entire team who do Open Source 101s and OTO, ATO are just absolutely fantastic. So this is really a fantastic opportunity to talk about things open source. And if this is your first time at one of these events, welcome. A little bit about myself. I've been involved with open source as a developer, but other things as well for many, many decades, as you can most probably tell by the gray hair. I've been really in the open source ecosystem for literally decades. If the name is familiar with you at all, it's most probably due to me being a co-founder of the Apache Software Foundation and being a core developer of a number of open source projects out there. But I've also worked at various companies, and currently I'm leading the open source program office here at Salesforce. But one thing that I think is very important to recall, especially in this talk, that we're talking about intellectual property, and that is, let me make sure I can get this done right.
Promise number one, I am not a lawyer.
That's right. I am not a lawyer. I am a developer. So this isn't legal advice. It can't be legal advice because I'm not a lawyer, not able to provide that. But this is really information and insight that has really been obtained by my years in open source, both as a developer volunteer, but also as my engagements inside various companies and things of that nature. So really, I think that there's going to be a lot of very good, useful information for everyone to take out of this. So I guess the main question is intellectual property. I mean, why in the world are we talking about intellectual property at an open source event, especially at an open source 101 kind of event? Intellectual property, how much more boring can you get than intellectual property, especially when there are so many neat talks about community building and what GitHub is and what open source is about and stuff like that. Well, the simple answer is that really, when you think about it, open source is and has been a reaction to intellectual property. And as you engage in intellectual property, as you interact with open source, as you either leverage open source or contribute to it, no matter what you do, you will interact with intellectual property. And not knowing what you're allowed to do or not allowed to do, not knowing how you're going to be interacting with it, can put you and can put your company and can put your open source project really at risk. So as boring as this topic may be, even though it is the major thing that drove the free software movement and the open source movement, is this reaction to the traditional ways of looking at open source, intellectual property is very important because you will be engaging with it. Now, there are four main types of intellectual property that we'll be talking about, and all of them at some various levels intersect and interact with open source. Now, the first one we're going to be talking about is trademarks. Now, when you think of trademarks, they are the logos, the slogans associated with an open source project. For the Apache Software Foundation, for example, it's the multicolored feather. One of the keynote speakers earlier today talked about how they are, ZSH and Bash are increasing their branding, their logos. Well, these are all trademarks. These are the things that identify the brand associated with an open source project, with an open source community, and with the open source entity, which is the governing body of this open source project out there. And one of the things that you really need to do to get the most benefits out of a trademark is you need to register it, or at least you need to make the external world know that, hey, this is a trademark of whatever. This is a trademark of the Apache Software Foundation. This is a trademark of the Linux Foundation. This is a trademark of some entity out there. And then that is enough for you to have ownership of that trademark. Now you can go formally and further officially by registering this as a trademark by using some sort of government entity out there. And that's how it's the difference between a registered and an unregistered trademark outside there. So a trademark is very, very important to an open source project because it is the brand in which a project is known by. But one of the things that you need to really recall is that just because something is under an open source license, because it is an open source project, it does not necessarily grant you the use of the trademark. For example, you can't go and create your own version of an open source project and then necessarily use the trademark of that official open source project. The trademark really is property that's owned by the open source project. In fact, in many ways, when you think about it, the trademark is really the only asset that an open source project, an open source community, an open source foundation owns, because the other assets that you would normally think of are assets that are given away for free, assets that are given away under a very permissive, unrestricted license out there. And so really at the end of the day, the brand is so important to the project because it uniquely identifies it. And so almost every open source project out there will have some page or some conditions or some requirements that detail how you can use the trademarks associated with it. There'll be naming structures associated with it. Again, going with the Apache Software Foundation. If I were to create my own version of Tomcat, the Java server container, I wouldn't be able to call it Jim Jagielski's Tomcat because it's Apache Tomcat. No, I can call it Jim Jagielski's version of Tomcat or Tomcat by Jim Jagielski's company, but I can't use the word Tomcat because that makes things confusing for the end user. When you use the word Tomcat, well, who owns that? Who owns Tomcat? If it says, all these other companies claim to own Tomcat, then it dilutes the value of the Apache brand of Tomcat. And that's the reason why trademarks are usually covered under different requirements and different conditions than the software usually is. So this is just a long way of saying that open source projects will protect their trademarks because they are really, really assets that they own, because they have built they have spent a lot of time and resources in creating this brand. And that brand is associated with that mark. And so they're going to want to protect that as much as possible. The other type of intellectual property that's out there is something that's known as trade secrets. And this really doesn't interact or intersect a lot with open source in the open source environments. The typical canonical examples of trade secrets are sort of like the secret formula for Coca-Cola, for example, or the specific blend of spices and herbs in KFC fried chicken. These are, parts of intellectual property that are so important and vital to the success of a business that they need to be protected. They are trade secrets inside of there. And there's really nothing inside of open source that interacts or interfaces with the concept of what trade secrets are about. You may run into it occasionally, but it's very, very doubtful that you will. But then again, for completeness, since we are talking about intellectual property, I did think it was important for us to recall that there is this one flavor of intellectual property that you might engage with, although normally you really won't. One thing you most probably will encounter is the idea of patents. And in the open source realm, it's really software patents. Somewhat similar to the concept of trademarks is a patent is something that you need to register. It's something you need to actually apply for to an official government or legal agency that says that you are the owner of this patent. If you don't patent something, then your ability to leverage the protections that a patent would normally provide to you are really significantly reduced. So a patent is something that if you really want to exercise it, if you really want to use it, you have to register it. And the reason why I'm focusing on this proactive action for patents and trademarks is because of the difference we'll see when we start talking about the idea of copyright. Now, as I mentioned before, most of the time, what you'll do is that when you encounter software patents in the open source realm, there is still this debate on whether or not software patents are actually good or bad. Is being able to patent a piece of software something that advances the open source movement? Or is it something that harms it or damages it? And I think that sort of conversation can't exist in a vacuum without realizing that the process itself is somewhat broken. I mean, patents themselves were really initially designed and envisioned for hardware, for concrete things, for inventive ideas that relate to a physical artifact that you can hold, touch, or whatever. Software really doesn't fit into that mold. And so there are a lot of people out there who are just questioning the idea of whether software patents are even a thing that's possible. Another thing that is discussed in the open source world regarding software patents is that if you are a company who has a patent portfolio, or if you are someone who's developing software and releasing it under open source and it's under a patent as well, how do you plan on using that patent? Are you using it in a defensive nature, preventing people from abusing the software patent? Or are you, for lack of a better term, a so-called patent troll, using it in a very, very offensive fashion where you're using it sort of like a club over people's heads and saying, okay, this software is one of our patents. For you to be able to use it, you have to pay us a lot of money out there. Most of the large companies nowadays, most of the large software companies that have huge patent portfolios have those patent portfolios in the open source world for defensive purposes. And in fact, there's actually an organization that helps combine these defensive packages and defensive patents in a way to protect the open source community out there. But you may interact and engage with patents as you start looking about your involvement inside of open source. And I guess the biggest question, or the biggest issue when we start talking about patents in the open source is that when you start thinking of open source licenses, what do the open source licenses have to say about patents? Is there an implicit or an explicit understanding about what is conveyed, what is possible, what freedoms or restrictions there are regarding any software patents that may have somehow be associated with the code base. What does the license have to say about that? And as we'll see in a few slides later on, there are some which are very explicit and clear about what happens if there's a software patent associated with this code base. There are others which are less clear. Maybe they have implicit understandings, or maybe there are unclear understandings outside there. So with those, I guess, lesser known aspects of intellectual property, let's really talk about the one aspect of intellectual property that is the most common and most well-known way in which open source interacts with intellectual property, and that's copyrights, the idea of copyright. Software licenses are a direct reaction to some of the restrictions inside of copyright laws. Now, one of the things that's different between copyrights and things like trademarks and patents is that you do not have to declare something under a copyright. If you write something, if you write some piece of code, even though, yeah, it'd be great if you put that little, copyright Jim Jagielski, 2022, although that's good and that's fine, that isn't what puts it under copyright. The very act of creation makes copyright protection pop into existence. So unlike the other things where you have to declare something or register something as a patent or register something as a trademark, the very fact of creation means that the copyright is now enabled. And now once that's done, it severely limits and restricts what other people can do with whatever it is you've created. So the whole idea behind that is that because copyright in and of itself is designed to prevent reuse, is designed to prevent people from adjusting it or modifying it or sharing it or things of that nature, the whole idea of open source and free software is to turn that on its head. In fact, that's the reason why there are various free software licenses called copyleft instead of copyright, is that it wants to take the idea of copyright, which is kind of restrictive, and turn it 180 degrees and make it much more open and permissible and do away with those restrictions and limitations that copyright enforces on the created product inside there. But there are a couple reasons and a couple selection criteria on picking what the best open source software license inside there. Basically, these are the goals associated with license types and license families out there. One of these goals or restrictions is to determine what remains open or free, what remains open source. There are some open source licenses where, hey, if you're using something which is open source, anything you do with it means that that code and every other piece of code associated with it needs to remain open source. There are other licenses that say, well, yeah, this code needs to remain open source, but if you modify it, that doesn't need to remain open source. Or if you put that in something else, you can do whatever thing you want in there. But that's one of the reasons why some people pick one license and one license family compared to another, is they want to control not only that existing software project, that existing code base, but also have some sort of control over the future direction, the future growth of that software project, and ensure that that code or any subsequent code associated with it remains open and free. Another way of looking at it is that in a lot of ways, when you're releasing something as open source, you are giving away some control. I mean, copyright is intellectual property. It's designed for it to be, this is your property and you have control over how it's used. Whereas with open source, you're giving up some of that control. And by selecting the different open source license, you can limit how much of that control you give up, or you can open up the amount of control you give up. But that sort of control, that sort of derivation is possible by determining what license type. And in a few slides, we'll actually talk about which license types actually provide these sorts of controls, which license type are best for these sorts of goals. Another reason why people release something as open source is to create an open standard. If you can have a reference implementation of an open standard under an open source license, then it provides sort of like the low barrier of entry that makes that open source standard, that open standard protocol prolific, ubiquitous out there. The best way of making an open standard useful, ubiquitous, universal is by having a reference standard available under as permissive as possible of an open source license out there. Open source and open standards go together very, very tightly, but this is another great intersection of where open standards and technology interact with open source itself. Now, when we start thinking about open source licensing, there are things that determine whether or not criteria, for example, that determine whether or not a license is considered an open source or a free software license. I'll use those terms somewhat interchangeably, even though there are some subtle philosophical differences between free software and open source. But basically, as far as free software compliant licenses, they determine whether something is a free software license based on whether or not it provides these basic freedoms to the software. That's the criteria that it uses. If it matches these 4 specific freedoms that the Free Software Foundation have defined, then it's a free software license. If it doesn't comply or doesn't provide these 4 freedoms, then it's not. With open source and the open source initiative, who are the stewards of the OSD, the open source definition, there are 10 criteria which determine whether or not a license is open source or OSI compatible or OSI certified. Some of these conditions are things like, fair use, no discrimination of end users and things of that nature. But again, there's a really set criteria on what aspects and what things a license must be compliant against. And the OSI certifies various licenses out there. I think in general, though, if you start thinking about the main ideas of what constitutes an open source license, I think it really comes down to the idea of promises. That this is a promise that the open source creator is making to both end users, but as well as contributors and anybody else who would be using or leveraging or somehow making use of the software that they're creating outside. Now, what I'll do in some cases is use an analogy where I'm pretending that code is actually cookies, like the actual, like an Oreo cookie. It's most probably the best example, the one that I use. So we'll use that as an example when what I'm talking about becomes a little bit difficult to understand. It's like, okay, I hear what Jim's saying, but what does he actually mean by that? And in that case, I'll use an analogy to hopefully simplify and make that a little bit clearer. I think the first promise that open source provides is the ability to use the software. Use it in any way that you want to. For example, again, using the cookie analogy, not only the cookie itself, but the recipe designed for the cookie. Well, you can use that recipe in any way whatsoever. We're not restricting how you use it, whether you just put it in a book and publish it out to other people, whether you use it personally to create your own cookies, that's really, really up to you. Not only that, but the end result, the cookie itself, you can use that any way you want. You can eat it, you can share it, you can sell it. You can even use it in a non-cookie fashion and sort of like make a gingerbread house, with it. that's a really strange use of a cookie. But that's sort of like unrestricted, unfeathered usage is something that open source and open source licenses are designed to do, is really allow you to use it in any way and as any fashion that you want with as few restrictions or limitations as possible. Another promise that it makes is that you can modify it to your own personal conditions, your own personal requirements. Again, if you're giving a basic cookie recipe and you decide that you want to go and add, chocolate chips or, something something else to it, for example, to turn it into a different type of cookie. That's modification. It's a modification of what you were originally given. That's perfectly okay. Another thing is that if you're actually given the cookie and you decide that you want to put icing or sprinkles on it after the fact, that's a modification of what you're given. And again, that's something which is allowed. That's a promise that's made in an open source license that says you are given something. If you want to modify it in whatever way you want, for whatever conditions you feel the need to change it, that's perfectly acceptable. We're not going to restrict you from doing that. And the third promise that's made is the ability to share these. Share not only the original, what you were originally given, but also share your modifications, share everything. So the ability to use it, modify it, and then share or distribute those changes or the original thing are, I guess, the three main promises that really go to the heart of what open source is about and what open source licensing is about. And you'll notice that the 4 freedoms of the Free Software Foundation and the 10 criteria of the open source definition all relate in some way to those 3 promises outside there. So now that we have sort of like this idea on what constitutes an open source license, let's actually look at some of the various license types out there. And again, I will be using the idea or the analogy of code equals cookies. Now, it has to be admitted that there are a ton of open source licenses out there. At last count, I believe it was something up to like 60 or so. And there was a period of time where you couldn't, every week it seemed as if a new open source license was being approved. Thankfully, that's been controlled and somewhat restricted now. But in general, if you look at that entire large family of open source licenses out there, I think you can boil it down to 3 main types, 3 main families of open source licenses, which you will encounter and use. The first type is what I would call the permissive or the give me credit types. These are, for example, the Apache license, the ALV2, the various BSD licenses, the MIT licenses. These are very, very permissive, extremely non-restrictive. It basically says you can do anything you want to do with this software project, as long as you give us credit, as long as you tell people that, hey, this software available from this location is part of what I'm providing to you. That's all you need to do. What does that mean as far as the license is concerned? Well, let's look at sort of like the traditional Oreo cookie. And I hope people know what an Oreo cookie is. It's that one with the, the 2 chocolate wafers, and inside the chocolate wafers, right between them, sandwiched between the 2, is that delicious, iced filling inside there. Now, say, for example, Nabisco, the creator of the Oreo cookie, used an open source license recipe for those cookies, for just the cookie part, not the icing part, just the cookie part. Well, when they release the Oreo cookie, they don't, just say, for example, that they took that recipe and they needed to modify that recipe because when it went through the stamping process, they put that little embossing on it, the cookies crumbled. And so they had to add more sugar or more eggs or something like that. But they took this permissively licensed cookie recipe and they modified it. Okay. And This modification was part of this distributed project called an Oreo cookie. Well, they would not need to release what changes they made to that recipe. They would not need to release the secret recipe of the filling, the Oreo filling inside of it. This is what a permissive license does. It basically just says, hey, they would just need to say, hey, we use this original recipe. It's available right here. We didn't come up with it. If you want a copy of it, you can download it here. But as far as the modifications they made to that cookie, as far as anything they did to make the fuller cookie, they don't need to release that. They don't need to make that available. That can still be a secret to that company inside of them. That's still protected information and doesn't need to be released as open source. So that's why it's considered a very, very permissive license, is that you can take something which is permissively licensed and actually close source it. You can take it, shrink wrap it, add features to it, and make a commercial closed source project out of it. That's actually something which is 100% fine with permissively licensed open source projects out there. Now, the second type, excuse me, is what I call the weak copyleft, or the give me fixes type. And again, looking at the previous scenario, in this particular case, Nabisco would be required to also publish the changes they made to that initial cookie recipe. You know, oh, this was the original, license. This was the original source code for the cookie. We changed this, we changed that, we changed that. They would need to release those fixes under a similar license. They would have to release those changes under whatever weak copyleft license that the original cookie recipe was associated with. Some of the more famous weak copyleft licenses are the LGPL, the lesser GPL. Some people mistakenly refer to it to the library GPL, but it's actually the lesser GPL. The Eclipse public license, Mozilla license. These are all weak copyleft license that says, we don't care what you do with it, but if you make changes, if you make fixes to the software that we've provided to you, then you need to release those fixes under the same license that we're providing it to you. So if you take, for example, an Eclipse public license software project and you modify it and you release a new project out there, you need to also release the source code under the same Eclipse public license of the fixes you provided. But that's all you need to do. In this particular case, again, looking at the Oreo cookie example, that secret filling, that the filling is still secret. You don't need to release the recipe for that. Just the fixes that they made, the modifications they made to the actual cookie itself. And this is what the weak copyleft does. Now, finally, there is what we call the strong copyleft licenses. These are the so-called give me everything kind of license out there. The most famous examples of these are the GPL and the AGPL. And these are the ones that say, if you create something new, given a piece of software that I've created, then that new thing you created also has to be under the GPL or the AGPL. Okay, so everything else associated with it, since you built it on top of this, you added capabilities, whether you added fixes to it or whether it's sort of like a cornerstone of a larger project, that larger project wouldn't exist without this. And therefore, this entire larger project has to be under the same strong copyleft license. In this case, if you're looking at the Oreo cookie example, not only would Nabisco need to give, the open source license for the cookie, the recipe, the license for the modifications they made, but they would also need to release under GPL, the strong copyleft license of the cookie, the recipe for that internal cream filling. And it's because of that stickiness of these strong copyleft licenses. Some people call them viral in nature. And even though I don't like the term, especially lately, due to the pandemic, it does kind of like get the concept around, is that this license kind of like attaches itself to anything else that it touches to ensure that that is also freely available under this strong copyleft license as well. So those are sort of like the three basic families. And that's a really, rough idea of how they interact and how they would actually impact your usage of these software projects as you're leveraging or consuming these projects for your larger project. For example, when we start thinking about governance models for open source projects, there are various governance models which lend themselves much more attractively to a specific open source license type than others. For example, there is a governance model for an open source project called the walled garden. And the idea behind the walled garden is that, yes, it's available under an open source license, but the community, the external community involvement, as far as figuring out the direction of the project or the list of features that will be included in a project, is significantly restricted. These are the kinds of projects which are usually controlled and managed by a single company. And so unless you're an employee of the company, you most probably don't even have commit bits to this open source project. So yes, it's under an open source license, but the goal is to make sure that the company or the single entity has overriding control over how that project grows, where it goes, what features are added, and things of that nature. So for these kinds of projects, the very, very strong copyleft licenses, the AGPL and the GPLs, are most probably the best suited for that. Because what it does is that, first of all, it's kind of like makes it it disenfranchises anyone from taking that code and modifying it, especially a competitor, because what will happen is that if that competitor makes it better in hopes of, leapfrogging the person who released the software in the first place, well, they have to release whatever improvements they made. So they put time into making improvements on the software project in hopes of releasing a better product. Well, those improvements have to be folded back. They have to be also available under an open source license. That means the original company can take them and there is immediate parity inside of it. So that's one way of creating sort of like the ideas on, we want to, not only control the development of the project, but we want to make sure that nobody uses our open source project to basically, beat us to the punch as far as that's concerned. The other governance model type is what's called the benevolent dictator for life. And I guess the main difference between that and the walled garden environment is that whereas in the walled garden environment, the controlling identity just assumes power. It says we are the people who are controlling it. Therefore, what we say goes. In the benevolent dictator for life, that power exchange is actually bequeathed by the community. The community itself, the open source community, says, we trust this individual or the set of individuals to make these controlling decisions for us. The best example of that is Linux, but it's certainly not the only example of that. But the idea behind that is that it changes the power structure. And in this particular case, there really isn't one license type that's better or worse. If there's a benevolent dictator for life governance model, all models, all licenses are valid, are equally valid. There's no, real, winner or loser or preferred license in this type of environment. And the third type of governance model is what I call the true meritocracy. And I realize the term meritocracy is still somewhat, weird. My opinion is that it really depends on your definition of merit. And if your definition of merit somehow mistakenly includes, gender or sexual orientation or race or something like that, then that is a messed up idea of what merit is. Merit is really what you provide to the project. the value of your contribution weighed against how much time you have to put towards it. But in true meritocracy, the main idea behind it is that the community itself is very flat. The hierarchy is very, very flat, very, very even. It's all about consensus-based collaboration. And in these sorts of scenarios, the more permissive licenses are the ones that usually work out better, because when you have a very permissive license outside of there, you really want to make sure that the reasons and the force to fork a project are as small as possible. You really want to reduce the amount of conflict that goes into creating a software project, because inside of meritocracy, you're going to be having natural collaboration. You're going to need to have some sort of way of funneling that high pressure point when you're creating software projects, and a nice low a permissibly licensed software project will allow you to do that. Now, in the little bit of time that I have left, I want to go through a little bit of potpourri, some additional ideas and thoughts about open source licensing and intellectual property. Sometimes you'll see the concept of dual licensing. What is dual licensing? And this is basically a single software project which is available under two different licenses. Now, the idea of having them under two different open source licenses is kind of weird. You know, if you have something available under a permissive license and something under a COPYLEFT license, then normally people will choose the open source permissive license as their usage. In most cases, what you'll see is a dual licensing scenario for open source projects which are trying to be commoditized, commercialized. So you'll see a company releasing an open source project under what they perceive as a very, very restrictive open source license, sort of like AGPL, for example, as well as under a commercial license. The idea being that people would be so, quote, scared about using an AGPL license software project that they will pony up the money to buy a commercial license associated with it. Not really a fan of dual licensing out there, although I do realize that, it's out there, will most probably always exist, but that's one of the reasons why people wouldn't possibly consider a dual license scenario. Another thing is that there is no one magical open source license out there. An open source license really is a tool, and we've talked, in the last 40 minutes or so about one of the reasons why you would pick one license over another. So don't think that just because this is the first one on the pull down on GitHub, that it's the license I should choose. You should really make wise decisions, figuring out what you want to do while you're open sourcing something, what sort of community you want to engage with, what sort of community you want to build. Is it a software project that you want to commercialize? Is it one that you want to build an ecosystem or an open standard about? These are the kinds of things, these are the kinds of questions to ask when you start thinking about what open source license you want to go to, because changing it can be hard. Not only changing it and going through the process of making sure that you have the required okays and approvals to be changing it from one license to another, but just the PR impact associated with changing a license can be kind of bad. We've really seen a lot of cases where companies have released something under a permissive license and then have, for one reason or another, regretted their choice in doing that, which made them, do some things which most probably haven't reflected all that well for them, which kind of like leads me into the other aspect, is that make sure if you're using something which purports to be open source, that it really is open source. Is it under an OSI approved open source license? Just because you found something under GitHub does not mean it's open source. If it doesn't have a clear and explicit license inside of there, it's covered under copyright, and the amount of permissions and what you can do with that software is really, really seriously restricted.
Hi, Jim. Sorry to interrupt, but I think we have 1 minute left on the time
Perfect.
for this slot. Yeah.
So, and two other things, open source is not a business model. Don't conflate the two. Again, we've seen a lot of companies which have made that mistake. So don't, Paul. And finally, don't minimize or think less of the whole idea of license compliance. Really spend time on making sure that any dependencies you pull in are compliant with the license you want it to be. That's it for me. I ask you to follow me. My Twitter handle is right down there. It's at JimJag. I thank you very, very much, everyone. And I believe we are basically out of time. I don't know if we have any questions, but definitely if you do have questions, don't hesitate to reach out to me on social media. You can DM me at JimJag. I'll be more than happy to answer your questions. These slides will be available not only on the Open Source 101 site, but also on SlideShare. Thank you.
Yeah, that was a great talk, Jim. Thank you. We really enjoyed it. And I think we have one question in the Q&A box. Would you like to take it now? I think
yeah, sure, definitely. Do we have
10
time?
minutes. Yeah, we have you can take this question for a couple of minutes. That should be fine.
Okay. If we have open source processes for humans, for instance, community metric systems in chaos, how do you recommend we make them widely available, but still protect their use? I'm not exactly sure we're talking about the actual processes or the code or the data associated with that question. So Samantha, I'm not exactly sure what you're asking there, especially how it relates to this. If you want, we can you can retype the question on the Q&A tab or hit me up on Twitter, and I'll be more than happy to answer it for you.
Yeah, so thank you for the talk, and I think I really enjoyed it as well. So it was very deep too.
Yeah, pretty good 101, right?
Yeah, I mean, it was beyond 101, to be honest. It took really deep and a very interesting view.
Right.
Yeah.
Okay, thanks everyone.